Want to give it another 2 minutes, Sarah? Another 2 minutes works.
Yeah, that sounds good. And I see we have Martin LaFalce, we have Amanda Jack, and uh Julia. Do we have are you or Eric presenting on behalf of the DA's
Uh,
office?
yeah, Julia can speak for herself, but she did let me know that the guest is going to be a couple minutes late.
Okay, got it. Thanks.
Yeah,
Wonderful.
Andy
Thanks,
is his name.
Will.
Sorry.
Okay,
Everyone,
great.
glad to be here.
Right. Should we get started?
To give you the thumbs up. I was looking at the clock. Yep. Has about the 2 minutes.
Awesome.
Perfect. All right, we'll kick it off.
All right. Well, this is a few rules of how we run our virtual Zoom meetings. So welcome if this is your first time joining us, or maybe this is the first time in a long time and need a refresher. Uh, You'll notice that everyone right now is muted except for our co-chairs, Andrea and Sarah. And any of the presenters will be unmuted as we go through the agenda for tonight's meeting. Following the presentations and the agenda items, we will call on any members of the public who wish to speak and ask questions or make comments. You can participate by going to the React icon on your device and pressing the raise hand feature there. It's not the wave or the thumbs up, those will disappear. Only press the raise hand button once. If you press it a second time, your hand will go back down. If you're calling in from the phone, it's star plus the number 9 to raise your hand, and then it's star and 6 to unmute whenever you're called on. Whenever you hear your name called by one of our co-chairs, you should look for a prompt on your device asking you to confirm unmuting. Only whenever they've called on you. The chat is available for technical support only to help with Zoom software problems. It's not to make comments to the presenters or the co-chairs. They will never see those chats. It's only for tech support. And finally, if you're using an older version of Zoom, you may need to go to the participants section or the more section where you'll find the raise hand feature there. And finally, the last thing, we encourage you not to wave at the screen or try to get our attention that way. If you want to ask a question or make a comment, we will probably not see you waving at us. So chat me, I'm here for support. And otherwise, Sarah, Sandrea, you guys can get going.
Great. Hi, everybody. My name is Sarah Chu, and I'm one of the co-chairs of the Social Justice Committee here at CB8. And so to start off with, can you raise your reaction hands? By a show of reaction hands, how many of you have a connection with working with the law or have a connection with the criminal legal system? Good. So I see some thumbs up here. So one of the things that we talked about in preparing for today's topic, you're going to hear perspectives about the discovery law. And if you've been watching the press about this particular topic, you'll know that it is a very spirited and robust debate. And so for people who have touched kind of any part of this discovery issue, um, there are very few who are actually neutral about it. And so what we decided to do as we were discussing about potential biases going into this meeting we're going to opt for disclosing perspectives and rather than trying to squeeze ourselves into something that we really aren't. And um, and so uh, because my organization has taken a position on discovery, Sandrea is going to lead tonight's meeting, and I'll be here to help with organizational matters. I may have a question or two, but I'm going to kick it over to my wonderful co-chair, Sandrea Coleman.
Thank you, Sarah, the extraordinaire co-chair. That rhymes a little bit. But anyway, greetings, everybody. Thank you for coming out to our Social Justice Committee meeting. We are excited to kick this off and have this conversation and this informational session with you all. What I would like to do is start with introductions of the panels. So who's here from the Manhattan DA's office? If they could raise their hand and just everybody could spend maybe a minute or less introducing themselves so the audience is familiar with who you are when you're speaking and so forth, which, yeah, so we could start like that from the Manhattan DA's office. Who's here?
And Andrew, yeah.
Hey, my name is Andy Warshauer. It comes up more formally here. I'm the Deputy Chief of the Trial Division at the Manhattan DA's office, and I also serve as counsel for emerging technologies. So on the tech side of things, I have kind of a portfolio there as well. And we've got some members from our community affairs team who I think some of you may know already. So I'll kick it over to Eric Straza next, I think.
Hey everyone, hopefully you can hear me okay. My name is Eric Straza, Supervisor of Community Engagement at the Manhattan DA's office, and I will hand it off to Julia just for a quick introduction.
Hi, everyone. My name is Julia Mayens. I'm a Community Engagement Coordinator in the Community Partnerships Unit, covering the Upper West Side and the Upper East Side. So you may see me at your meetings. During this conversation, after this conversation, please feel free to follow up. Happy to have, carry on these conversations and be a contact should you have any questions for our office. But looking forward to the discussion. Thanks so much.
Welcome, welcome. Next up, Professor Martin LaFalce. I hope I'm saying it right, from St. John's University School of Law. Hello, hello.
That's right. Thanks so much, Sandrea. My name is Marty LaFalce. I teach at St. John's Law School. I direct our defense clinic here. I worked at the Legal Aid Society for 14 years as a public defender. And so I definitely bring a perspective to this conversation as a public defender, and I'm eager to engage with all of you on this topic.
Great. Welcome, welcome, welcome. Amanda Jack from the Legal Aid Society and Alliance to Protect Caliph's Law.
Thank you, Sandra. Yeah, hi, I'm Amanda Jack. My colleagues also call me AJ. So if any of you know me and hear that, I'm one and the same. I was a public defender in Brooklyn and then Manhattan, started in 2011. And for the past year and a half have been the policy director of the Criminal Defense Project, here at Legal Aid. I also want to note my colleague, Conliffe, is also on the call just to help with any questions. She is my partner in all of this in protecting discovery and a supervisor in the training unit at Legal Aid.
She introduced herself. Can she be unmuted? Just to say hello.
Oh, thank you. Sorry, I was just planning to listen, but hi, I'm Kali. And as AJ said, I work in our training unit at Legal Aid, and I practiced in the Bronx for a decade. So I'm happy to be here, and of course, we'll be happy to answer questions. But I think you have it covered. A lot of experts.
Right. Welcome, welcome, everyone, one and all. And keep in mind there has been some information disseminated on our website and so forth regarding this meeting that you can turn to, some handouts, fact sheets, letters, and so forth. So we're going to kick it off. We're going to kick it off to the Manhattan District Attorney's Office to start it off.
I think we're starting with the professor first.
Okay, we're going to start with the professor. Okay, all right. And I'm going to turn my volume down a little bit because I hear a lot of background. Okay, Professor.
Thanks so much, Sandrea. Thanks so much, Sarah. I really appreciate it. So, I practiced as a public defender in Manhattan for more than 10 years, representing clients charged with anything from misdemeanor marijuana possession to murder. And I practiced before discovery reform was enacted in 2019. And before discovery reform was enacted, we would typically not receive evidence until the eve of trial or the day of trial. We wouldn't receive video surveillance. We wouldn't receive witness statements. We wouldn't receive police disciplinary records. We wouldn't receive meaningful evidence at all. In many cases, particularly in misdemeanor cases, we wouldn't receive evidence at all pre-plea. And discovery reform has radically changed that dynamic. Discovery reform has opened up our criminal system in a way where we are able to see evidence in a way that we could never see it before. We can see body cam, we can see witness statements, we can see medical records, we can see police disciplinary records, and it has brought a measure of dignity to a system that denied people the ability to see the evidence against them for so long. So in my perspective, discovery reform has been an unmitigated good, and it has been a had a powerful transparent effect on our system. I want to show you an example of a case from our clinic. So I direct the defense clinic at St. John's, and students in my clinic will represent clients who are charged with misdemeanor offenses in Queens Criminal Court. And I'm going to share my screen here so you can see this. Okay. Are you all able to see this PowerPoint presentation? Just thumbs up if you can see it. Great.
Yeah, go ahead and hit the present. There you go. Now we can see it.
Great. So we represented a client who was charged with menacing with a weapon in Queens. The allegation is that he was working as an Airbnb cleaner, and he was confronted by a person outside of the home that he was cleaning. And the person claims that he menaced him with a weapon. The complainant said that our client menaced him with a weapon. There was a history of conflict between the complaining witness and our client. And the complaining witness called 911. Police arrived on the scene. And we got to see what the police first saw when they arrived. And so what I'm going to show you here is body cam of police officers who arrive on the scene and speak with civilian witnesses. The civilian witnesses had ring cameras that captured the entire incident. So the police in this body cam are speaking with civilian witnesses, and those civilian witnesses are showing video surveillance to the police officers. Listen to what they say.
And then someone contract. Nothing at all happened.
Okay. So the civilian witnesses are looking at video surveillance that captured the incident. They say to officers, nothing happened. Officers then discuss with one another what took place.
There's nothing. There's nothing happening. The night has happened.
It doesn't show anything. He has cameras facing this way. Literally nothing happened. They never came out, nothing. They were just clean. And this guy, I don't know.
So the officers say, we've looked at the video surveillance and nothing happened. No one ever came out.
But what time did this happen? Because we looked from 3:30 until 4:15 when we got here. And he never comes outside.
That's a lie. There's no way.
There's a camera footage.
Okay, I'm gonna show you what time it all happened. This is what time it happened. This is what time I was speaking to my girl.
Mm-hmm.
And this is, matter of fact, might have happened here.
3:43. We looked from 3:30 until
It's impossible.
until 4:15.
It's impossible. That's not possible. It's not possible.
I mean, so
It's not possible. If you legitimately looked at that, it's impossible.
we looked at
And you're
camera
lying to me
footage
right now.
facing this way.
I'm telling you.
It's on my body.
Okay. So the officers confront the complaining witness. They say they have viewed video surveillance, and they say that nothing happened. And so they then go on to say that it would have been impossible for the complaining witness to have seen this happening based on the perspective that the complaining witness had. They discuss that in this body cam. They conduct a search of my client's car. No gun is recovered. Okay. And so this is a case where my client ends up being arrested because a supervisor directs the officers on the scene to make the arrest. And so my client is arrested. He's charged with menacing with a weapon. And his case goes on for 11 months. We get this video surveillance early on. We get this body cam early on. And we're in a position where we can actually defend him. We can actually represent him effectively because we see what the officers saw. And his case was ultimately dismissed. But in a pre-discovery reform world, we would have never received his body cam early. We would have never been equipped with a full understanding of the case at every court appearance that he came to. And there's a good chance that we would have resolved his case in the absence of that discovery with a plea to a violation, just to resolve it, just so that he wouldn't have to come back to court. In the past 2.5 years, our clinic has represented approximately 25 clients, and 4 of them have been exonerated because of discovery that has been turned over early. If Governor Hochul's proposal was enacted into law, it would not be a tweak of discovery reform. It would not be a right sizing of discovery reform. It would be an effective repeal of discovery reform as we know it. And in my client's case, one thing that Governor Hochul's proposal does that I think is the worst aspect of her proposal is that she creates 2 categories of evidence: evidence that is constructively possessed by prosecutors and evidence that is actually possessed by prosecutors. And her proposal only imposes sanctions on prosecutors for a failure to provide evidence that is actually possessed. And that would absolve prosecutors of an obligation to provide discovery that's possessed by police. And our enormous concern is that the body cam that I showed you, where officers are saying again and again and again, nothing happened, where they're confronting the complaining witness and saying, nothing happened here, where they're seen viewing video surveillance that showed nothing happened, Governor Hochul's proposal would absolve prosecutors of the responsibility of providing that evidence to the accused. So I know I've taken a decent chunk of time. I'm eager to answer questions. I'm eager to answer questions about data. I'm eager to answer questions about the governor's proposal. I'm certain that folks from the Manhattan DA's office have disagreements with what I have said, and I invite a great exchange about those disagreements. Thanks so much for having me.
Before you mute, we would like you to just give a brief basic definition of discovery, and then we're going to move on to the next. We're going to let all the panelists speak, and then people take notes, hold your questions, and then you'll know who to ask from. So we could just flow like that. So if you can give us a basic definition of discovery, then we're going to move on and just everybody else will speak, and then we'll come back with the questions.
Sure. Discovery is information that is possessed by the prosecution, possessed by law enforcement, that relates to the subject matter of a person's case. And discovery consists of different types of evidence, sometimes video, sometimes witness statements, sometimes medical records, sometimes police disciplinary records, sometimes DNA, sometimes chemical tests. And all of that material must be provided to the accused where it relates to the subject matter of a person's case. In most cases, the material is possessed by law enforcement. In some cases, discoverable material is possessed by non-law enforcement, and prosecutors have an obligation to try to obtain it.
Thank you. Thank you so much. Next up from the DA's office, please.
Hey, everybody. My name's Andrew Warshauer. I've been told we got about 10 minutes, so I'd like to use the time and then get hopefully quickly to questions because I'd rather resolve the things that are in your heads than not. But I actually think Professor LaFalce's example is a great place to start about why we think this law needs tweaks and that we are seeing some, I guess, unfair demonization of the governor's proposal. Professor LaFalce, and I think Amanda, who will say much of what I think we just heard with some additions, is absolutely correct that the law as it existed prior to 2020 was intolerable for the defense. It was unfair. It was unjust. I practiced under it and like to think that I disclosed evidence sufficient for people to make decisions right, but I wasn't compelled to. You know, it was kind of within, are you going to be an ethical lawyer today in a way that the law does not require? So I'd say to you, if somebody comes and asks your community board to endorse Article 240, which is the predecessor to 245, as it existed in 2019, you should reject that, and that person has not come to you in good faith. Where we differ, and I think in the overall world of ideas, from having spoken to Amanda and Callie, I think we probably agree on 90% of this world, and the last 10% is what we do for a living. But I do disagree that the changes proposed by the governor remotely take us to where Article 240 was. And I think Professor LaFalce is right that this law has radically changed the practice. It has delivered evidence to people. It has made sure that our lawyers, our prosecutors, actually evaluate the cases in front of them in a meaningful way before they answer ready for trial, which means, hey, we're going to go to trial today. I could tell you stories, people having no idea what the proof in their case was, and they're making plea offers to people. That is not a fair system. That is not the system we want. It's not the system we will operate under if the changes proposed by the governor are approved. So I think frequently, if I was opposing the discovery bill in court, the move I would make would be to say this is going back to the old law because the old law is indefensible. What I don't see as frequently is real engagement with the terms and the language in the proposed changes. So one thing that I want to differ with the professor on is that this law only compels us to turn over what is in the prosecution's actual possession. I hate the way that provision is being read. It may need to be rephrased, but it's being read in the same way that Antonin Scalia reads the Second Amendment. They have read out of existence the first half of the sentence. The actual clause says, discovery by the prosecution. In effect, what the prosecution has, quote, after the exercise of good faith and due diligence, only then is what is in our actual possession compliant. So if we come and pick a random Tuesday and say, I'm going to open up my case file and turn over everything I have, and that case file is not the product of a diligent effort to examine 21 categories of evidence, the most in the country, then that provision of what we actually possess fails. It's not based on diligence. The Court of Appeals has tried to make this the current state of the law. I don't know why it's controversial. The Court of Appeals in People versus Bay at the very end of 2023 said this law does not require a perfect prosecutor. It requires that we have a prosecutor exercise due diligence and act in good faith to gather evidence. And then once they've done that, their certificates of compliance, which are how we say we are ready now to try the case, we've complied with discovery, should be valid. The problem is the way that law has been imposed in New York City and in some courts upstate. The Bay Court wanted to say people have complied with their discovery obligations, prosecutors have complied with discovery obligations when they have made a diligent effort to pursue all the evidence in the case. All the factors in that case point to this being a case level analysis. Did they give you 95% of the evidence? Was what was left somewhat minimal? That's diligent. Now, the way it's played out in court is a court will identify one document, the pre-arraignment report. Did you diligently pursue the pre-arraignment report? Well, I didn't know it existed. Well, you couldn't have been diligent. You have no emails showing you pursued this thing. Therefore, your case is dismissed on diligence grounds. So we've had a basic undoing and unraveling of Bay in the criminal courts. And I'd like to show you, as opposed to the body-worn camera, which, by the way, under the governor's proposal, would have to be delivered. And we have systems now in place to make sure it is delivered. And you heard from the professor it was delivered very quickly. I don't know if it was a matter of days or weeks, but under the current law and the changes proposed by the governor, that body-worn camera reaches the defense. What I want to show you is a pre-arraignment report. I can share my screen on Zoom, having turned into a creature of Teams.
It's the green button at the bottom. It says share.
There we go. It couldn't be more obvious. So
no, it's okay.
Over to, hold on. This is a pre-arraignment report.
We can't see it yet. So you're going to want to hit publish or.
There we go. Yep, got it.
There you go.
So this is a pre-arraignment report. It's not the body-worn camera footage of somebody committing a crime. This is a document that we get cases dismissed for not providing every day. It reflects nothing that is of meaning to a case. Sometimes we can get it, sometimes we can't. It never appears particularly relevant. It communicates to a defense lawyer the things that happened at the arraignment the defense lawyer was present for. And I want you to take a look at this and compare this to when you hear a person should have the evidence against him or her before they make decisions on their case. I agree. But cases should not be dismissed for the non-provision of this summary form that no one will ever use in a case. No one will ever cross-examine someone based on this. And I know this because the cases that don't have a speedy trial clock are our murder cases. And no one has ever asked me for a pre-arraignment report on a murder case. They've never asked me for underlying attachments for a meaningless disciplinary file on a murder case, because these are not things that are useful in defending a criminal case. They are useful only in getting that case dismissed on technical discovery grounds. So think through that again. The one place you can't get the case dismissed for the speedy trial clock, because it doesn't apply, is a murder case. The most important case your client can ever face. If these documents are critical to defending a murder case, why does no one ask for them on it? And the answer is these are, I think, well-informed and strategically smart decisions by very good defense lawyers to make sure they can get their client's case dismissed. And when that dismissal is not on the table, this is not worth pursuing. So the things we're trying to solve for in backing the governor's proposal are not denying Mr. LaFalce's client or his student's client access to the body-worn camera. I want somebody to point me to the provisions in the law as changed by the governor that say that would not arrive. What I want you to keep in mind is all of the things like this pre-arraignment report. Now stop sharing because these have real results. We frequently are told only misdemeanor cases get dismissed for discovery violations. That's not quite true. It's only criminal court cases, so they are misdemeanors and unindicted felonies. And there are impacts on our felony practice that I'll get to in a moment. But misdemeanors include a great deal of domestic violence. They include a great deal of sexual violence. And if you walk down the street and punch someone in the face on New York City streets, that's a misdemeanor. So the cases you're going to hear poo-pooed as this is only a misdemeanor problem in New York criminal court are spousal abuse, sex abuse on the subway, somebody groping a stranger at random, and someone punching someone in the head. So we had a recent case where someone had been abused by their boyfriend in front of his friends, stripped naked in front of his friends. She went through the ordeal of coming through court, multiple appearances, cooperated through the entire process. We did not provide, in that case, disciplinary histories, one of the things cited by Professor LaFalce. In particular, the only disciplinary file we didn't get was one that showed an officer had let someone slip out of his custody in the hospital for 20 seconds. He was cited for losing control of the prisoner. got him back under control in 20 seconds. He had let him loose to get a drink of water. We didn't turn that over. The case was dismissed. No order of protection, no legal recourse, and importantly, from where I sit, there's nowhere else in the country this happens. There is no legal system in the country that has mandatory dismissal. Judge can't do anything else. Mandatory dismissal for a non-prejudicial discovery violation. The most prosecutor-unfriendly law anywhere else in the country requires you to at least show there has been harm to the client to get dismissal. That's what we're seeking. There is still, in the law as changed by the governor, dismissal under the speedy trial law as a sanction for any prejudicial noncompliance that can't be cured by other means. That means if the court can't fix the situation. We didn't turn over a report saying there was a video camera. And by the time we turn it over, the defense goes to get the footage and the footage is gone, that case is dismissed. The judge has no say in the matter. They must dismiss. Other cases, the disciplinary record, the pre-arraignment notification report, the judge has the authority to dismiss. But they also regain the authority to do other things. Preclude a witness, delay the trial, say you can't question about a certain thing, as it is in every other state. And, I think importantly, individualizing the remedy to the case. Right now, the legislature has made this call on every case, current and future. The legislature is not informed by the facts of the case. They don't hear arguments from the parties. They have just decided for every court from here to perpetuity that the sanction for discovery violations, I hate saying that, often it's belated disclosures, and we know this because somebody's saying, hey, the thing I have in my hands, I can now tell you I didn't get earlier. The precondition being I now have it, right? Like the harm in Article 240 was people never got it. In this case, you're going to get it. That is where we're trying to get. And, I really fear that there was such a breakdown in the trust between everyone in the legal system because of how abusive the prior regime was, that no one can come to this and presume good faith on the other party's part. Because from where I sit, we are trying to back what I view as the most anti-prosecutor discovery law in the country. And the fact that I'm sitting here advocating for the governor's changes to this law, they confuse me. I'd like to show one chart because I think I don't have a rebuttal period here, but the last one I'd like to close on is right here. Okay, if I can share my screen one more time correctly, I hope. I'm not sure we can zoom in closely on this. If it's too illegible, I'd love to have somebody say so. But if you go through every other state, and we've tried to highlight the kind of more progressive jurisdictions in the country in green, and I can distribute this. Kings County, the Brooklyn DA's office, has synthesized all this through some heroes' work. There is no other state that comes close to the law we're going to have. Even Texas, which gets held up as a model here, there are some categories they automatically. Generally, it's material to any matter in the action. If we were restricted to providing those things that are material, I would be thrilled. We're not even arguing for that here. What we're arguing over are things, one of the things we've argued over is whether we should have to provide things that are related or relevant. I'm not sure what the case is for providing admittedly irrelevant things to the defense, but it's one of the places we're hung up here is that we don't want people providing things that are only relevant. They must be related. Related has been held to encapsulate a lot of things. I'll give one more example that's on appeal now, so I'll try to anonymize it a little bit. Hopefully it'll be available once the appellate process is further along. So I hate saying, trust me, on this one, I can't really identify the case, but a very ugly sex crime. I don't want to go further into the facts than that. But the prosecution was handed off from prosecutor 1 to prosecutor 2. Prosecutor 1 never gave the successor prosecutor a series of text messages where they coordinated schedules with a witness. Can you come Tuesday? No, I can come Wednesday. Let's come Thursday. A detective had the same on his private phone. In one of those text messages, the victim expressed that she was upset at how an interaction with the defendant had gone. That is related to the case. She was expressing her emotions at having been abused. It's related to what happened to her. That case was dismissed. 3 years of litigation. This survivor has shown up in court devastated to hear that her sexual assailant had his case dismissed because of scheduling texts to which she reacted wrong. What if she had said nothing and just said, I can be there Monday? Maybe that's not related. But her honest emotional reaction now causes that case to be dismissed. That's not a law that we need to tolerate, and we can fix this without undoing all the good that we've done and all the good that this bill has done. And it's done real good, which I didn't anticipate. My criticisms of this law in 2019 were apoplectic, and I think in retrospect, especially as to the victim safety portion, overblown. That stuff has not come to pass as we feared. And I think we should be able to admit when we've been wrong about fears we have about the future. But the case dismissal fears are real. And I'll leave on this stat, and I think I'm over time. I apologize. The stat that keeps getting cited is that superior court cases, the ones that are indicted, the ones that matter the most, are not being dismissed at a higher rate. That's true. That's a very selective stat. We are downgrading felonies at rates no one is comfortable with, which is why when you look at the aggregate arrest data, we used to dismiss 28% of felony arrests. We now dismiss 42% of felony arrests. That's a 50% increase in the cases that reach us as felonies that get dismissed. And if a hospital came to you and said, yeah, we still cure the same number of patients, the same percentage of patients we admit, we're just turning away 2/3 of them at the door, that's not a good hospital. So yes, we have been able to maintain our conviction rates, our disposal rates, et cetera, on indicted cases because we're fire hosing resources at them to get discovery compliant. And we are ignoring a great deal of crime where the cases should be adjudicated. They don't need to result in state prison. Many I wish would result in treatment. Some should result in dismissal, but they shouldn't be resulting in dismissal because of this inflexible law and its kind of only remedy to any problem being dismissal. We can have a more discretionary system that still causes meaningful production of discovery to defendants, as I think Professor LaFalse's example shows. That body-worn camera, and I'm happy to go through step by step, still reaches the defense under the governor's changes. And I think I'm 5 minutes over now, so I'm going to step aside, but I'm happy to answer questions later. And thank you all.
Thank you, thank you, thank you. Next up is Amanda Jack, also known as AJ, as said. You're up.
It's true. I'm a 1980 baby, and Amanda's and Jennifer's were everywhere. So I was the new kid and the fourth Amanda in the third grade. Thank you for taking the time to think about this. I'm going to zoom us out and then kind of go back and just try to quickly answer some of AJ Warschauer's points, because I do think that it's most important to get questions. I want to first say, we're organizing against these proposals with the Alliance to Protect Khalif's Law. And if you've lived in New York City long enough, you probably heard the name Khalif Browder, but I just want to raise up why, with the permission of his family, we used his name. Khalif Browder was the young person who was held at Rikers for over 3 years, most of that time in solitary confinement, allegedly stealing a backpack. It was allegedly with another young person, so it made it a felony. And the portion of the law, when the discovery and bail laws were reformed in 2019 and implemented in 2020, the portion of the law that refers to the connections to speedy trial was named in his honor, because after he left, he shared his story. It really was the driving force for these changes, especially in the discovery part, because these discovery laws they've been trying to reform discovery in New York for about 20 years, a little more than that. An assembly member named Joe Lenthal, who spent, almost half a decade in the assembly, was chair of codes, have been introducing automatic discovery bills for years and years. They have been listening to stakeholders, getting input from both sides of the argument, refining, and really working to push this through and to modernize, to bring us out of the blindfold era. And it was really Khalif's case and his tragic death by suicide that animated the final push that got us over. And I say this to reorient, because 20 years of thoughts and inputs cannot be addressed in, a 1 hour community board meeting, nor should it be addressed in a budget process, because that's what we're talking about right now. These proposals are part of Governor Hochul's budget process. And to undo decades of thought and input when the laws are only 5 years in and were paused, the enforcement mechanisms were paused during COVID for about 2 years, is a really hard pill for me to swallow. And I think that these kinds of conversations need to be had. And, I've been so happy to talk to different community boards in Manhattan about discovering the process and what happens to our clients. But the truth of the matter is the right to see the evidence against you is a fundamental right. And in Khalif Browder's case, he wasn't being given all that evidence, right? But also the prosecutor at that time could start and stop the trial clock, and they weren't held to account by any kind of speedy trial statute because the judge could say, you know, if evidence was turned over late, the prejudice to the defense and the defendant, the person accused, could be cured by an adjournment. And that's how we would get to these cases lasting, in Khalif's case, 3 years. In the years I practiced before discovery reform, I would stand next to a client at arraignments and they'd say, hey, Miss Jack, like, how long until we get to trial? And I'd be like, well, it depends on a lot of things, but I'm going to trial next week on a case that's 3 years old. I just finished a case that was 2 years old. And this was because we don't have a speedy trial statute in New York. And that's what I want to focus on too, because ADA Warshauer talked about how these are the most anti-prosecutor discovery laws in the country, and everyone else has a prejudice standard. So many other places also have a real speedy trial statute where you're arrested and within, for misdemeanors for us, it's 90 days, 90 calendar days. If the government isn't ready to go ahead, the case is dismissed. And that is the case in most of these jurisdictions. That is not the case here. We have a prosecutor readiness statute, right? And even with the tying of speedy trial to discovery, with the tying of speedy trial to discovery, that's what we are trying to solve for, right? It doesn't make sense that the prosecutor can start and stop the clock with no real oversight. And that's how we got to this kind of, you know, this was part of the years of mass incarceration, and that's how we got to these long waits in court. And so I just I wanted to share that bit of history because I think it's really important, especially just from, you know, the hyper localized situation and what's going on in our communities and our neighborhoods here in the city. It's really important to remember that this is a law that protects evidence sharing, fair and timely and open and automatic evidence sharing. And I like to say, like, you know, say the story of Khalif Browder doesn't resonate with you, how would you feel if a loved one was accused of a crime, or if you yourself were? We all deserve that fundamental right to see the evidence against us and not to have to wait years. And that's really what's at stake here. And so I wanted to zoom out on that and say that the accompanying piece that I think is the thing that has been unsaid and is often unsaid is that this has required an enormous culture change in prosecutor offices. And quite frankly, I've said this to Andy before, it hasn't happened because what happened in 2020 on January 1st when these laws were implemented, I was working night court that night on New Year's night. So I rang in the new year in a very excited way as a public defender on that night. But what hasn't changed is that from that moment on, that's when the start to try to repeal the laws began. And in fact, in that budget process that year in 2020, bail and discovery laws were touched. The discovery laws were amended again in 2022 to close these loopholes with defenders and prosecutors talking together. And so some of the cases we've heard have been the same cases and examples and anecdotes that we've heard for years now. So I just want to say that to me, that's really illustrative of the gargantuan task of changing culture in offices. You know, AD Warshauer now has a third boss in, you know, as many years, but like AD Morgenthau was the DA here in Manhattan for decades upon decades. And that's a really embedded and deeply held culture, right? And so even when you get new DAs, we're still working to change that and to change the fact that what this has meant, access to evidence, means that we're not taking, to Professor LaFalce's point, these time-served pleas right away, because we can actually say to the people we represent, hey, it's tied to speedy trial. There's enforcement now. They have to give us the evidence. They have to give it, not just give it to us eventually, but give it to us in a timely manner, 90 days on a misdemeanor and 6 months on a felony. So I'm just putting us back in that's some of the frustration we feel on the defense side, that it has required an enormous amount of culture change. And we haven't been seeing that because from day one of implementation, we've been withstanding these attacks on these laws. I also want to just say quickly that the one provision that was kind of talked about at most, the construction, the possession, like what does the DA have versus what the police has. The important thing to note here is that I appreciate that, you know, in ADA Warshauer's telling of how this would work out, it would be the diligence would come first and the good faith. I understand that language is there, but I think what we also need to talk about, that if the actual possession is taken up in a court, that would still allow them to, as long as the prosecutor requested something, stop that speedy trial clock. And really, that's the culture change I'm talking about, is most of these proposals all can kind of flow back to having control over that speedy trial clock, because that's how coerced pleas happen. That's how wrongful convictions happen. And these changes would take us back to that time and create those environments, right, where there's this frustration with the process. The process is the punishment. And that's really like the issue here. And to take away NYPD, to say it's something that's not in their possession, is also really missing the point here, because something that we didn't discuss is that these dismissal rates in criminal court, they are only up to this extent in New York City. The rest of the state, some of the large population centers, the dismissal rates are actually down. And I think that's really important, because what we hear day in, day out in the 5 boroughs as a legal aid society is ADAs standing on the record explaining to the court why they don't have the evidence yet. And it's because the police have not handed it over. And there are other types of evidence. There are hospital records. There are, goodness, ring cameras everywhere. But that is like the most often heard complaint. And that's why we really believe that this can be solved with direct access to the evidence that the police have. You know, people watch Law and Order, the prosecutors and the police work as a team. That's what we're asking for here, is for that direct flow of evidence to be happening, which will of course help out the prosecutors to get it earlier and to review it. The case that ADA Warshauer brought up, I actually spoke to the attorney, the defense attorney on that case, because one of the frustrations is that this was a case with a published decision, but it was reported very hyperbolically in the Post. It was a misdemeanor case. And my understanding is that the evidence was given over on the 84th day, the first discovery. The 90th day is when these cases get dismissed. So that's another problem, right? Is that diligence means timely diligence too. That's part of the considerations here, is like we don't wait to the very end to give that kind of evidence over. And some of that could be the NYPD not giving it over. We hear that all the time. So we can fix that problem. The other thing I'll respond to quickly is that ADA Warshauer, I think, also really named the solution and the problem in the same breath by saying that the Court of Appeals, our highest court in People v. Bay, talked about the diligence, right? They said there's no requirement. This is that the prosecutor has to be perfect. There's no requirement for a perfect prosecutor. And diligent prosecutors who act in good faith, which means what? People who are doing their jobs, right? Who are doing their jobs, they don't get cases dismissed for inadvertent mistakes. And that analysis is baked in. And to the ADA's point, it's not maybe being followed by all of the judges. So there we go. There is our second solution, right? Our second solution is let's do more training for judges. Let's make sure this trickles down into a jurisdiction as big as New York City that has so many more criminal court judges, many of whom come into the criminal courts without prior experience in the criminal courts. Let's get them trained. Let's make sure this very clear factor analysis from the highest court about our discovery statute is understood and applied evenly. And all of this comes together with the fact that we are still getting our technology up to speed. So this was an unfunded mandate. The prosecutor started getting money first, and the next year we said, hey, we need it too. We get the same amounts, terabytes of discovery. And we've been getting that. Legal Aid got the first round of, like, we received the money earlier than our defender colleagues, and we only got it this past fall. And so we have started to get the technology up to speed, right? We chose the same technology as the DA's office so we can talk to one another. That still isn't fully online yet. Many of our defenders, our sister defender offices across the state, haven't even gotten the checks cleared from the state, right, to start doing this. We know here in the city, not the DAs aren't all up online either. So a lot of this is about reorganizing the way we manage our individual cases, our teams, hiring up litigation assistants, getting the technology in place. And then the two solutions, one of which I believe was just named in Andy's recitation to you all, which is to make sure the judges are actually following the law as it's applied. This is a statewide law. This is a New York City problem, and this is a statewide law. And we have very progressive prosecutors here in New York City. To change the law for the whole state when it's a problem that's only happening in the city, and to do so in a rushed budget process where the governor's proposal only had input from the prosecutors and not from anyone else, that to me isn't good government, and that requires us to really take a pause and consider what we're doing and bring it back to the heart of why we pushed for so many years for these reforms, which is that discovery is about a fundamental civil right to see the evidence the government has gathered against you. The government has chosen to prosecute you. They have the duty to then share that evidence that they're going to use in your case. And when we do that, timely and with diligence and good faith, we can stop the cycle of wrongful convictions and coerced pleas. And that's what we're talking about here. And so I think we should move to questions. I don't want to keep talking. There's more to say, but I did want to say one final thing about the most anti-prosecutor laws in the nation. In North Carolina, if you don't turn over the evidence, criminal charges can be filed against the prosecutor. In Florida, you get to depose, meaning that the defense attorney can go ask questions before trial, the police. So there are other much more open states. We finally caught up. We went from bottom four to, yeah, really good open evidence laws. But it's time for us to start using them, allowing them to breathe, to change our culture, to adapt to them, and to really leave behind a really shameful legacy of wrongful convictions in New York State.
Thank you. Thank you. Thank you to all the panelists for bringing your perspectives and evidence and presentation, all of that. We appreciate that because we want to have a robust discussion. We're going to open up for questions. I'm going to go to my co-chair just to see if she has any questions before we go to any raised hands. Savage?
Yeah, thanks, Andrea. So one of the areas where I hear consensus on from both AJ and from ADA Warshauer, I think, is the question about resources. And I was wondering exactly how much was it the state budget? Were they local New York City budgets? And how recently was the funding shared, or I guess appropriated, received, and implemented? And what else do your offices need? So there could have been funding and it might not have been enough, but in terms of resources, what would your offices need to feel like you had the person power or the technology in order to respond to the challenges that you're facing?
Do you want
Go
to
ahead,
start?
AJ.
Okay.
Good.
So the funding, and correct me if I'm wrong in the DA funding, but the funding did not accompany the passage in 2019. But I believe the first year that the prosecutors got funding for discovery was in 2021. But I'll let Andy correct me on that if I'm wrong. Defense, we got it in the fiscal year 2023 budget. And so this would be the third cycle that we'd get it. But as you can imagine with our state, it takes quite a long time for that to trickle down. So we were the first offender org in the state that got it. It was 40 million for discovery for defense and 40 million for the DAs as well. There was an extra pot of 50 million that was allocated in the state for the DAs, but my understanding recently is that it came down and the mayor's office in criminal justice either gave it to the police or sent it back, but they didn't actually get that. So they had, and there's like a few million more in the prosecutor bucket, but it's 40 million for the discovery and then another 40 million just for aid to defense. So the technology we get out of one bucket. And then at the Legal Aid Society, we've been able to hire paralegals who we call litigation assistants. And this is a model that Danny has had to, like trial prep assistants. We never had it at Legal Aid. We didn't have the funding for it. And I know it wasn't as widespread, I think, at Danny, but what's great is they help us organize the discovery. And so it's like you need the technology, but you also need the people power to help, see a case through, help organize it, see what's missing, and understand it too. There are a lot of body cams to watch. So for us, we'll be getting it hopefully again in this budget cycle, and it's really helped to be able to have those systems online. Andy might be trying to talk.
Yeah, I'd been forcibly muted. I had to mute myself again because there is a 7-year-old, a 3-year-old, and a 1-year-old in the background who don't want me talking about discovery reform anymore. But on we go. I don't want to get. I work for a state agency. We're underfunded. We can always use more money. I don't want to be misleading here, though. There is no amount of money that pays our way out of this. I think the 2019 budget, and by the way, the discovery reforms in 2019 were passed in the budget. I know we don't like to do that now, but they were part of the 2019 budget. They were passed with $0 to accomplish them. And there were quotes on the Senate floor that said the goal is to make prosecutors triage and do fewer cases. It was said out loud back then. Now I'm told it's crazy that we say we can't do as many cases, but that was said on the floor of the Senate. It's in the record there. and no dollars came with that bill. So I think the intent of it was somewhat clear. The money came to us. We have hired people. We're trying to bring on programs. That money does a really good job of, once we have things that we know exist, we can process them and move them quickly. So I think they greatly benefit the defense bar. Our problem is not processing what we have. It's not knowing what's out there. It's not knowing the text on the detective's personal phone. It's not knowing the employment records that Judge Ward is going to find to be relevant, which is mind-boggling to me. And it was said, the case examples are from a long time ago. One was January, one was last month, and one was today. So, these cases keep rolling in, and we've tried to buy our way out of it. To be honest, I think as a single percentage solution, can you get 5% efficiency gains? Yeah. But to undo that 50% jump in dismissals and huge amounts of downgrades, structural change is required. We've tried to do this, we haven't been able to, and it's not a New York City problem. A letter was issued today by every other DA in the state except I think one, saying we don't know why people are saying this is a problem, citing cases that have been dismissed for these very reasons. I'll circulate that letter if people want it. I don't think the DA's Association of New York State has a great amount of credibility with the state legislature, so I don't think it's going to have an impact. But I suppose every one of those elected DAs could be lying. But from where they sit, they are saying we have this problem in my county too. So yeah, I don't know what to say in the tech part. We can get better at processing that which we already have, but that's not our problem. Our problem is finding the stuff that we don't know exists, be it in the NYPD's hands, a hospital's, a private cell phone, or otherwise.
If I may, I'd like to respond to the funding issue. I know that in so many rounds of discovery debates with the legislature and the governor year after year, the compromise has often been more funding. I wanted to give an additional perspective, which is that DA's offices across the state have to make choices about what is a priority to prosecute. And so when I was at the Manhattan Legal Aid, I represented clients who were charged with selling M&Ms on the subway. I represented clients who were charged with selling bread in Chinatown without a license. I represented clients who were charged with selling bottles of water on the Brooklyn Bridge without a license, selling Dominican flags at the Dominican Day Parade without a license. I represented clients who the Manhattan DA's office sought prison time for possessing utility knives that they purchased at utility stores throughout the city, Home Depot, Lowe's, Ace Hardware. Represented clients who were charged with felony drug sales for selling drugs to undercover officers outside methadone maintenance clinics. And so these are grave abuses in my perspective of government power. And we haven't had reconciliation for those grave abuses, and we should. But more than that, prosecutors have to make choices. And one choice is to not prosecute the drug sale outside of the methadone maintenance clinic as a felony. Not to certify discovery, but to resolve it with a misdemeanor. Not to prosecute the Chinese immigrant who's selling bread in Chinatown. And it happened in BT1. We can, kind of name the supervisor who was responsible for that. But prosecutors' offices can make choices not to do that would make their obligations less burdensome.
Okay. We're gonna go to the hand raise. Thank you everyone for chiming in. Valerie, you're up.
Yeah, and while we go to Valerie, I'll just remind everybody, if you would like to participate, you can go to the react icon on your device and press the raise hand button.
Thanks, Will.
Hi, everybody. Thank you very much for presenting this. I think this is a very difficult thing to absorb if you're not involved in this on a day-to-day basis. Just so people who are looking at this, we have the proposed text of the changes in the chat, so you can kind of pull them up and take a look at them. But I have a couple of questions. They're a little bit all over the place, so forgive me if I don't start in the right place. But I want to just go back to something that Andy said, just on your, are you saying that 50% of the felony charges are dismissed because of a deemed failure to follow this? I was a little unclear about, what. Okay, thank you.
Sorry,
Can you
that's an
just-
overstatement. And let me give the best example I can give here. The NYPD makes arrests for a variety of charges. They can charge a felony, they can charge a misdemeanor. That's not binding on our office. We frequently disagree with them. Prior to the discovery laws being implemented, about 28% of all cases the NYPD made felony arrests on ended up in dismissal. That number now stands at 42%. That number probably would be north of 28% now based on our policy positions. I don't want to mislead anybody here. Like, it might be 30, it might be 31. DA Bragg is somewhat more progressive. All of the NYPD has changed what they make arrests on, so they can kind of move that into denominator as well. But I thought one of the good ways to look at COVID was the excess death numbers. In the absence of some other compelling reason, how many more deaths are we seeing this year? That to me is kind of the canary in the coal mine number. We used to dismiss 28% of all felony arrests. It's now 42. There's no world in which it would have been less than 28, but there is a chunk of those dismissals. There are a chunk of those dismissals that are undeniably due to our inability to bring cases. And to just to answer a couple of the points from the professor, I prosecuted some of those cases. No one liked prosecuting those cases. We knew which supervisors were going to make you prosecute those cases. Those arrests aren't being made anymore. They are summonses. There is not a single Manhattan case that we're going to get discovery compliant on for a bottle of water on the Brooklyn Bridge. And Amanda, if I am wrong about that, bring me the bottle of water on the bridge and I will scream holy heaven at anybody involved in the prosecution. That is not where we are in 2025. I understand the years of buildup of seeing people suffer under those cases, and I don't want to downplay it, but I don't want people to think that if this law changes, someone's going to be arrested, get discovery compliant, and tried for selling a Dominican flag at the Dominican Day Parade.
Okay, so let me go to one of the changes. AJ, I'll let you answer in a second. But one of the changes is saying that you would only have to turn over evidence that was relevant to the subject matter of the crime. So if this law gets passed, okay, you wouldn't have to tell anybody about, you wouldn't have to, if you didn't reveal the records of the arresting officers that perhaps targeted a certain race or type of person, that would not, the defense would not have the right to say you didn't hand over the proper evidence because you're saying it has to be related to the subject matter of the crime, when in fact, the failure to turn that over might be relevant because the person who was arrested was actually targeted.
Yeah,
I mean, am I reading that wrong? I mean, I'm reading it on the fly, but that's what it seems. It seems to go a little bit beyond the materiality of the evidence.
So to my mind, materiality is actually a stricter standard than relevant. Materiality means there's a likelihood that it would change the result of the case. Relevant is broader than that, right? Related is even broader than that. So
right
now,
but it says subject matter, okay? Yep. And the case was turned over, the domestic violence case that you're talking about that was in the New York Post recently, related to what you're saying really is an irrelevant disciplinary action that was taken against one of the arresting officers. And I'm not sure that what adding subject matter relevance wouldn't absolve the DA's office from turning over a relevant prejudicial arrest record of a particular arresting officer, which may be relevant, but doesn't have anything to do with a domestic violence case.
So the line we get in most judicial opinions is that the credibility of a testifying witness is always relevant to the subject matter of the case. So that there is kind of a provision for that, but I don't want to mislead anybody here. That the analysis of disciplinary records is about the thorniest legal issue you're going to run into in discovery. There are certainly, you have planted evidence on someone before. There's no way in which that's not discoverable. You have a pattern of discriminatory stops. I could come to a place where, if that officer transported a person from point A to point B and had no other involvement, I'd argue that was irrelevant if I had to. I wouldn't want to. But
Okay.
I think we would like to get to a place where there is some discretion over. We had one good case, guy had lost his parking plaque on the Williamsburg Bridge, flew out his window. Had a case dismissed because we didn't turn over those records. I don't know where the room between those two things is for a judge. I would hope that a thing that is irrelevant to the subject matter of the case does not form the basis for dismissal. But we're still under a duty to pursue disciplinary information as to our officers. And let me get into the weeds a little bit. The problem that we have is not identifying the nature of the violation most of the time. It is in getting what are called underlying attachments. So it is the notes taken by the person who investigated the infraction. It is the audio recording of the interview with the officer. So we're almost always going to be armed with some idea of the guy's stopping people with no reason. He's been found to have perjured himself. He's been found to associate with somebody who was charged with a crime. So, there's not a blindness to that. I think what we do want built in is when it is somebody slipped out of your custody for 20 seconds and you're not really a key part of the testimony, that case doesn't need to be dismissed.
Okay, so let me switch gears just a little bit, because one of the items that's being proposed in the legislature, it's not the proposed changes to the text and discovery, but this idea that the information is being shared between the police and the DA's office, regardless of whether. So are we saying that if that law passes, that anything that's on a police computer would also be deemed in your possession because you're sharing files?
It already is deemed in our possession. Anything the NYPD has, we are constructively charged with having, which means the law makes no difference between what's in our doors and what's not.
So you're saying that that law is irrelevant then?
No, that law, the one introduced by Senator Myrie and Assemblyman Lasher, would compel the NYPD to give us direct logins to the evidentiary systems that they have. The problem, there are lots of problems with it. I like that bill. I'd love to see that bill passed in conjunction with what the governor has recommended. It would lead to, I think, a lot of efficiency gains. It talks about evidentiary systems. It doesn't get to disciplinary records. It doesn't get to detectives' phones with private text messages or employment records. CCRB is an independent body that is outside the NYPD, that there are large amounts of discoverable stuff that cases get dismissed for that the Myrie-Lasher bill does not address. It would save us a lot of time in getting the core evidence we need, body-worn camera, witness statements, detective files. We could get all that to the defense faster if that bill passes. But we won't avoid some of these, the detective had texts on his phone level dismissals.
Okay, well, let me ask you a question. Would that be available, AJ, to legal aid if they had a case number that you could go in that system directly and get it yourself?
No, our only access to the cops is when they're on the stand and we get to cross them.
Okay. All right. Well, I guess I'm a little, to your point, AJ, unfortunately, most substantive legislation is in a budget bill purposely. Not just this, but we can talk about a whole slew of legislation that gets passed as part of a budget bill in order to, I don't know. I'm not going to speak for the governor, but she wouldn't be the first governor to do that. And she's obviously not going to be the last. But, I agree with you. I'm not sure that that's the best way for this to go forward. But I'll just end by saying it's very, it's very difficult, I think, for people who are not involved in the system to try to completely understand what the ramifications are of these bills from both sides, because I think somebody used the word hyperbole or hyperbolic, and that can be used on both sides for egregious examples of how evidence being withheld really hurt somebody. And then on the other side, how a victim's been wounds and life change has been compounded by the fact that somebody walks away on a technicality. But I'm looking at the proposal again in real time. And Andy, I think, you're coming from a good place, but I'm not sure that what's the language that's proposed in that bill is really substantively meeting up with what you're saying it should. I think it's, in my opinion, a little bit short and maybe could use a little bit more tweaking, if you will, as a lawyer would say, which I am, a little bit more tweaking to address some of the concerns. But thank you for answering my questions and for coming here this evening.
Well, Valerie, while we're here, I'd love to address if you think there's a specific part of the language, if it is the relevant versus related. Happy to talk now or later. You know,
Well, I
this
think
is where
we
gotta
all need
communicate.
to. Yeah, I appreciate that. I think we all need to look at it a little bit more closely, and I think that this discussion is very eye-opening, so people can take a look at it and maybe evaluate the fairness or the unfairness of it from both sides. So I haven't really let AJ talk about her viewpoint, so I'll be quiet.
No. We want to hear the questions. There are a couple of things that I wanted to push back on from AD Warschauer. I did want to say, I take your point about the budget. This is what my fourth session in Albany, and I get it. But the difference with when it passed was that it had been discussed for years and years and years ad nauseum. Different stakeholder meetings, public hearings, different versions of the bill. And I think what feels so awful this time is, despite the fact that even defense attorneys across the state, we have monthly meetings with the governor's public safety team. And we know that this is always bubbling up. And I would ask, like, are discovery changes afoot? Can we talk about it? No. And then suddenly we find out about it like everyone else in the state of the state. So that's not a collaborative process. And I think that's what feels so difficult in this space. I also wanted to say, one thing that I would like to dispel is that cases are not dismissed on technicalities. Now, under the law, Andy, and this is what you yourself said, People v. Bay does not allow for that. And, at the public hearing in Albany for the public protection hearing, discussing this proposal in February, Chief Administrative Judge Joe Zayas, grew up in Manhattan, was a judge in Queens, and then worked his way up, said that in order for a case to get dismissed, this is how it's supposed to happen under the case law and the statute, right? That a defense attorney would have to show that the prosecutor did absolutely nothing, right? Was not diligent. This is not the question here about these technical dismissals and dismissal sanctions. This is getting confused with what we're saying, what Bay says, what the statute says. You don't have to be perfect, but you have to do your job with good faith. It's really hard for me to push back against some of these examples we're hearing, these case examples, to your point, Valerie, about hyperbole, without reading the decisions. Because when I read the decision about the case that ADA Warschauer talked about, I had a very different take of what the facts were of that case. And I think that's why this rush process is really difficult, and especially if you're not within this defense prosecutor world. The other thing I'll say, I don't know if water bottle cases are being prosecuted, on the Brooklyn Bridge, but you know what is being prosecuted? Turnstile jumps. You know what happened in Brooklyn just this past weekend, which this is a statewide law? A man who was arrested for stealing $214 worth of goods from the Home Depot that were recovered died awaiting arraignments. And you know who else was in that arraignment part with him? A man who was arrested in the middle of the night for taking up 3 seats on a subway. A quality of life crime that I remember weeping when I first encountered as a young attorney, that actually existed. We're talking about a statewide law. We're talking about different prosecutorial practices in each county, and we cannot forget that. And I will also say, the other point on this is that your office, Andy, your indictments are up. You've indicted more cases this year than last year. So everything has a context. And I know that we're in this world where data doesn't mean anything. I looked just now to see if the data site was back up for Danny. When Alvin Bragg came in, they did this. Well, Cy Vance did too, a data site. It's not there. The data that I see says that indicted felony cases that have been indicted by grand juries, that those dismissal rates have not changed. They are less than 1% and have been so since 2019. So it's really hard to have these back and forth without seeing the specific case in these moments, and then also understanding where the data comes from.
I have a quick question for Amanda. I don't know if you want to chime in. I might be interrupting what Andrew might want to say or ask, but 50A.org, has that been useful to you all as defense attorneys with, finding, because I'm a former member of service myself, NYPD, not a cop. I used to supervise payroll. So yeah, I'm just curious, has that been a tool that more useful for you all, since that's
Yeah, absolutely. I mean, also, because you probably know this if you did payroll, oftentimes when a police officer is found to have committed some kind of misconduct, they shuffle around to a different precinct, right? Or a different borough too. So for sure. And I also say something that was said earlier about the Civilian Complaint and Review Board records. Those are actually automatically shared with the DAs. And we have a letter from the general counsel there to that effect. So one of the things too is 50A was repealed around the same time as these discovery laws too. So there's some more systems, like more sunshine, more light, more oversight and accountability is what makes us a healthier society. So yeah, it's been helpful. I think we have daily fights in court about misconduct records, but it allows us to put a check on a system that receives the biggest part of our city budget, right? The NYPD, and that has outsized power just in the weapons, officers carry around. And without making further comment on that, I think it's fair to ask that there's accountability, especially where there's misconduct.
Thank you. Andrew, did you have anything to say before I go to the next hand?
I think, I don't mean to be flip, but I wish we had Judge Zayas ruling on our cases. If he thinks the standard is there is no dismissible for a technical remedy, I've got a pile of decisions sitting in my office to show him. Second, the insistence on training, to be fair and address you directly, Amanda, you're saying the judges need to be trained to ignore the arguments your lawyers are making. The legal aid version in Albany just could not be more different than what we see argued by your attorneys every day in court. Legal aid Albany is we come in peace. No case gets dismissed for one minor report. Legal aid Manhattan Court is you didn't give me the simulator solution lot from a factory in Ohio 6 years ago. I need that. Your case needs to be dismissed. So yeah, I'd love to have the judges trained. And by the way, I'd trade judges with any county upstate. If you'd love to ship our bench to the 4th Department and trade, I think we'd have better dismissal stats. But I do think focusing on the training of judges to ignore the arguments being made in court it is tough.
Yeah, okay.
So I didn't know if somebody was responding there. I don't know if someone was muted or not.
Yeah, it wasn't.
Yeah, I mean, listen, every one of these things we can go back and forth. Technically, CCRB takes 3 to 4 months to give us most stuff. Sometimes it's routed through the NYPD first. There's a gap in there, and we're still charged with getting some of that stuff in some courtrooms. So yes, any individual issue, we could do this for hours at a time, Amanda, I'm sure. And I don't think anybody really wants to hear all of it. But the state of play is I have to sit down with people, our lawyers have to sit down with people and tell them, we didn't turn over this piece of paper, like that pre-arraignment report, and your case is now dismissed with prejudice. Your order of protection is gone. Your attacker will never see a courtroom. That happens. You can shake your head, Amanda. I sit with these people. I talk to them and I tell them their cases are over and I listen to them cry. So I know you've had your clients, you've had emotional experiences. We have too. And it doesn't need to be this way.
I'll just say, there's other hands raised, so I don't want to go back and forth all night. But one thing that I didn't say in my presentation is that one of the problems with blaming discovery laws for survivors having their cases dismissed, one, it ignores the state of the actual law and how it should be applied. But two, it ignores the very real reality that so many people who are charged with crimes are survivors of interpersonal violence. And so to say, like, this recent rhetoric has been around this issue. And I just want to stand up and say that I have represented so many people who were currently or in the past victims of interpersonal violence. And this binary that we're being asked to accept all the time is the problem with how we can't get past this kind of dark age of mass incarceration and overcriminalization and arresting people for taking up an extra seat on the subway in the middle of the night. And I just really want to push back on that because, again, there are standards in place and there's judicial law in place, and it's a law kind of still in its infancy, and that will, I hope, trickle down. I'm Legal Aid Manhattan and I'm Legal Aid Albany. So like I'm one and the same, and I have had these same back and forth in 100 Center as I have up in Albany. And I just want to say, like, for me, I think that's what feels so frustrating, that we're also relying on saying that there's no more orders of protection when family court is right across the street from 100 Center and you can walk in and get an order of protection. And like using the criminal system like that, it hasn't served us. If it did, we'd be the safest country in the world, right? And so there's so many more ways we need to evolve beyond the past. And I think that's what we're asking. We finally did that in 2019, and by adding a little sunshine into our discovery laws. And there are systems that we can use, there are trainings that we can employ, and there is a law that is fair and just asks prosecutors to do their jobs and asks the police to do their jobs and hand over the evidence. And I think that's where we are. Let's let that play out. Let's stop the wrongful convictions from happening and coerce police from happening. And let's make sure when the government brings a case, it follows through with its duty to give evidence over to.
Thank you. Barbara? Oh.
I may say just one thing very, very quickly. I served on the Mayor's Advisory Committee on the Judiciary, which was responsible for vetting judges who sit in criminal court. And I served for over a year and a half under Mayor Eric Adams. I wasn't appointed by Mayor Adams. I was nominated by St. John's. And when we talk about dismissals by judges in New York City, it's important to keep in mind that we don't have kind of radical folks occupying the bench in New York City. We have many former prosecutors. Judge Ward was mentioned. I think all parties who have appeared in front of Judge Ward recognize that she's a law and order prosecutor, and she's not going to willy-nilly dismiss a case on the basis of a technicality. Our Court of Appeals has a four prosecutor majority on it. And so when our laws are being construed, when dismissals are happening in New York City, it's not on the basis of a technicality. It's not on the basis of a pre-arraignment card. These decisions are because prosecutors have failed to be reasonable. That's the standard announced by Bay. That's a part of CPL 245. The prosecutors have to be reasonable, not perfect, but reasonable in their efforts to provide discovery.
Thank you. Barbara?
I'm more than happy to send a case which was dismissed for a pre-arraignment report. That was not in my open PDFs right now, but it's there, and I will send it to whoever here would want to see it.
I have a couple of questions and a couple of comments. One comment is, and please accept if I'm wrong, but from what I'm hearing, the complaint about the change is because in the old days, where the AD admitted was the not right, pre-2019 was bad. I haven't understood, and maybe it's my lack of intelligence, what in this is the complaint. The complaints all seem to be pre-2019, and I think, Andy, that I'm right in saying that you would agree that before 2019 was not right, was not perfect.
I think not perfect is
Is it
it's kind of a way to put it. And I think the defense lawyers here can speak better to that. But yeah, it's not which we should return.
Right. So that's one comment. If I may go for a couple of others. One is what I've heard. I am not an attorney. I'm on the community board. I'm very concerned with things. My committee that I'm co-chair has the judicial system is part of it. I was starting to work on this. So I have to admit, I know a little only as a layman along with it. But over the years, I always heard that one of the horrible things, of course, is Rikers, that we have so many complicated things that make it wrong, and that the defendants or they are languishing in this horrible jail and come out. I then read this, and it seems that the prosecutors have to present within a certain amount of time. So why is it that it takes so long for a case to come? Is it because the defense attorneys are holding it up? This is what I was told, and I don't know if it's right, and I'm asking a question. Why should it be that somebody is in jail, the horrible Rikers? And I always say the 11th commandment should be that we should not partake in NIMBYism, but there are people on this call that do partake in spite of what they think. And I know that's one of the problems that's happening, that the jails are not being built. And I know it's more confusing than that. That's the second question. The third thing I'm going to say, and I know there are those on the call that are going to say I won't make it to heaven, but that's okay. I don't believe in heaven anyway. I do feel that there are two victims. I have talked to several ADAs. They're people that I like, I have respect for. Not one of them was a pig that said, I just want to put somebody innocent in jail. They go to the Innocence Project. They welcome the Innocence Project to see if there's anything to be done. Every single one I talk with compassion and not wanting anybody to be convicted that is in fact innocent. However, I as a mature person, to be nice about the word senior is a better word for it, is we do know that that there's a relatively small number of people that recommit the crimes over and over again. And what I hope for everybody on this phone, on this Zoom, is that nobody will have a loved one that is murdered by somebody by a murderer that has been convicted 3 times with an illegal gun. And this is what's happening, and there has to be a balance. I do not know, and I stopped reading about it. I do not know if this solves all the problems, whether we've defined what's a minor piece of paper, was, something, a discovery, what should be considered a major discovery and whatnot. I'm not sure. But certainly, we've only really heard, except from the AD, one side, that the person of stories about the conviction. And from what I see, they won't happen now. Now, I'm going to answer a couple of the crimes. First of all, the jumping the turnstiles is a problem, and I don't think they should languish in jail, but certainly something should be going on with it. The one thing that AG talked about that I'm sorry, I got emotional about it. I have a friend that lives on 114th Street and Park Avenue. She owns a 4 apartment. She lives in 2 and rents out 2 apartments in a lovely house. In her area is where there's the methadone clinics, et cetera, et cetera. The place has been ruined. The neighborhood's been ruined by the drug dealers. To say that a drug dealer should not be convicted is just not fair for everybody else that's living there. And so I'm sure I know I was told that I like crime and all of that. I'm sure I'm being thought of badly, but I think you often have to say, who else is the victim? It's not just one side. So I had several questions.
Good.
Okay, thank you, Barbara. I don't, no one think, I'm not thinking of you badly. I've lived in the city a couple decades. I've been the victim of gun violence, and I am also a survivor of interpersonal sexual violence, right? So I come at this, as so many of us do, from both sides of this as well. I do want to say, I'll try to answer, I'll answer your questions in reverse order, but I wanted to say what you were just talking about, to me, is one of the most frustrating things about this rhetoric around discovery, which is evidence sharing. Evidence sharing cannot cure, nor, in my opinion, stop recidivism, right? Or and facilitate recidivism. It's evidence sharing. In fact, because we can now say to people, what's going to happen if I don't take this time served plea at arraignments? I can say, well, there's 90 days. You jumped a turnstile in 90 days. We'll see what they do with the case. Like we'll have they also cannot, they can't take away the plea until you see the evidence. That's another really helpful thing about the 2020 law. And so for 3 months, at least, if the case does get dismissed in the end, or we end up taking the time served plea, for 3 months, someone's checking in with the court and checking in with me, the public defender, who has a bevy of social workers in our office too, right? Might consider misdemeanor treatment court. Instead of just me meeting them at arraignments, sometimes, arraignments go to 1 a.m.
I have to assume the ADA would absolutely agree with you.
Yeah.
Should we have more mental health? And it's something that my committee has fought for. Mental health help. Should we have more drug help along the way? Should we try to get people at an early? I know that DA Bragg has tried to have like Saturday night basketball and clinics and all. I had a buddy for 6.5 years in the South Bronx. I went twice a month there. I think I know a little bit about it. Absolutely. But at the time when they're doing the crime, I have sympathy for background. Many of us have had bad mothers and so on, but that's not an answer to the victim that has been hurt.
But how does not sharing complete evidence on time help that victim?
I don't know, because what complete evidence means. I don't know. Somebody else want to answer? I think the answer is, sorry?
I'm happy to jump in and how it plays out. Yeah.
Amanda, sorry. Can Amanda finish? Because I think she was, Barbara had interjected. So let Amanda finish, then you could jump in. Because yeah.
Yeah, no, that's my question. Like, I honestly, the initial, the headlines in the post and the initial comments by the police and the mayor that led up to this discovery proposal sounded just like the bail reform and rhetoric that we've had for the past couple years. So I just want to challenge us as a group and all of us to get beyond that and to understand that what you're talking about, Barbara, in my estimation, is not something that the criminal system will ever fix. 55% of the people at Rikers Island right now have a known serious mental illness diagnosis. It is our largest mental hospital in the state, right? One of the 3 largest in the country. Like, that's not okay. I sit with Danny, we're trying to work on more mental health courts because there have been times where I have sat as a white woman attorney with other white woman attorneys in their treatment court unit, no social workers present, and been told that my client is too mentally ill to go to treatment court. It's not a solution. We have to, and it doesn't also stop if any violence did occur. It's already occurred. So we have to stop using these tools of policing and prosecution that happen after some kind of alleged violence, and really think about how community-based resources can work. And I'm so happy to talk about that. And that is a conversation I want to have all the time, because there are solutions. But I don't think it bears on evidence sharing. And just to answer the first question you had briefly, the 3 major things, there's lots of things in this proposal. Someone in the Senate called it death by 1,000 cuts. And that's true. That's why we call it an effective repeal. The 3 real big things that would take us back to the old days are: 1, what I said, instilling a prejudice standard, meaning that it would allow the DA to stop the speedy trial clock to complete discovery, right? And we'd go back to these days of repeated adjournments. At 2, the actual and constructive possession, which I think we talked about a lot, which would allow the DAs to stop the speedy trial clock by saying, I've turned over what I have. And then we would say, well, you didn't turn over enough, but the speedy trial clock would be stopped. And then 3, we also talked about relevant versus related. So those are the top 3, I'd say, things they do. It also does things like allows the DA to redact items without judicial oversight first. And there's other things in there, but those are the 3 headlines. And I can't, of course, it's a proposal that I hope never comes to fruition, but those taken together would take us back to the blindfold era. And so that's why the stories we have are from pre-2020, right? Which, Professor LaFalce and I both, and my colleague practice, the bulk of our career is pre-2020, right? And those proposals would take us back there with the starting and stopping of the speedy trial clock, and to a really dangerous place where DAs had discretion over what's relevant and what's important to our defense.
Andrew, please chime in.
Yeah, I mean, I do want to be mindful that I think we're at 8. I don't know. I don't want to drone on forever because I could here. The way in which this becomes relevant to recidivism is boring and dry and bureaucratic, but it's this. When you raise the price in person hours of every case we have to get compliant on by between 300 and 400%, which is about the best estimate we have, we can do fewer cases. And as you see in the data cited by Legal Aid, we didn't start dismissing murder cases and rape cases and gunpoint robberies. We have kept those indicted felonies from being dismissed. And we've done that by throwing all the resources we can at those cases. But that means when somebody shoplifts 6, 7, 8, 9, 10 times in a week, and we used to stop and charge a felony on the second one, we don't have the budget of hours to do that. So that pattern of victimization tends to go on longer, and someone has to cross a higher threshold before we can afford really to bring a felony case against them, which has a meaningful intervention, either in terms of a better treatment court with Medicaid funding and real consequences if you don't participate meaningfully, or state prison. So it's a bank shot. It's not a satisfying argument, but we can do fewer cases under this law. As one of the state senators said when passing it, we would be able to. And now, because of those fewer cases, the ones we've had to dry up, shoplifting, burglary, lower level nonviolent robberies, are the cases that get downgraded more substantially these days. Yes, we are bringing more indictments than we did in 2019. Crime in 2019 was at the lowest level since 1942. So in this crime environment, which I'm sure everyone here feels differently about New York in 2025 than they did in 2018, yeah, there's more crime. But as a percentage of the arrests that reach us, we are indicting too few cases. We are getting compliant on too few cases. We don't need to get compliant on all these cases. We don't need to go back to prosecuting water bottle cases and people sleeping on the seats. And if there is a Manhattan case where we have filed a complaint for someone doing that, I would love to see it. So no, there is a impact on recidivism in the budget of hours we have available to do property crimes cases. I think you also asked, Barbara, about trial delays, and I want to be I think mindful of the fact that that is a problem that has a lot of different parents. There's court delay, there's prosecutorial delay. There are times, I mean, sometimes I can be overly blunt. I'm going to get yelled at in my own office, but there are times at which a prosecutor thinks it is tactically sound for them to wait. We don't want them to. There are times at which defense attorneys think it is tactically sound to wait to bring a case or to bring a motion, and they delay. And you know what? Those lawyers on a case-by-case basis are probably right, and they're trying to do well in their cases. That's why we've got to step back from our roles as advocates and say what's good for this system as a whole, not this client or the next client or this conviction or the next one, but what's going to make a durable system that we can all operate under, because this is not going to go away with this budget session. If there is no fix to these structural flaws that are fatal, in my view, to this law, we're going to be back at this next year and the year after, because we're not going to let these cases and these victims go. So, this is not a problem that is one budget vote away from everybody shutting up if it doesn't go our way. These problems will exist before. There will be problems afterwards, because this is still a very aggressive law that requires a huge amount of cost and effort on our part. If we dial it back the way the governor's proposed, we can all live with it. And I think we can ensconce it in a way that is reasonable and durable and keeps New York a leader.
Thank you. Judy? Thank you for your patience. 2 more hands raised. Hang in there, please.
May I just address one thing that Andy said?
Okay.
So on the issue of someone being arrested 7 or 8 times in a week, our bail law covers that scenario. And so there's a provision in our bail law called the harm plus harm provision that allows a judge to set bail for a person who's been repeatedly arrested in a short period of time. That's number one. Number two, there's a provision of our trespass and burglary law that the Manhattan DA's office relies on all the time, which allows a prosecutor to charge a felony when a person has returned to a store and stolen for a second or third time in violation of a notice that prohibits them from going to the store. And they go from facing a year at Rikers Island to 7 years in state prison when they've stolen in violation of that trespass notice. And so the person getting out after 7 or 8 arrests in a week is not an experience that we see in our system in a significant way. The other thing I want to share my screen to show actual recidivism data. And if I can here. Okay. So this is recidivism data from the Division of Criminal Justice Services. And if you take a look, I've controlled for what happens 6 months after a case has been dismissed. What is the rearrest rate 6 months out after a case has been dismissed? And from 2013 until 2022, the number has hovered in between 20% and 18%, excuse me, 20% and 15%. And in 2022, the most recent year for which data is available from DCJS, we see a rearrest rate after a person's case has been dismissed of 18%. It's squarely within the range that we've seen for years. And so claims that recidivism has spiked because of evidence sharing, I think is entirely inconsistent with DCJS data. So that I just wanted to share that.
Thank you.
Yeah. I don't know if my colleagues from Legal Aid have something they want to say. I wanted to jump on 2 parts of that, though, if I can. The first is the harm provision. And I don't think we're here to debate the bail laws, but the harm provision applies when you have an open case. So if I steal once and I'm arraigned and I don't plead guilty and I go out and steal again, I'm eligible for bail. If I steal on Monday and plead guilty to time served and steal on Wednesday and plead guilty to time served, when I steal on Thursday, I am not eligible for bail. Only open cases count. And we see this all the time. I don't want to name him by name. Happy to send it to somebody who represented him. We had somebody arrested 53 times on 17 different dates, and he had time served imposed on him. Each one of those charges was either trespass or petty larceny. Not things we're seeking huge sentences for. But the idea that, and that was in 1 calendar year. So 12 months time, 53 arrests on 14 different arrest days. So yeah, I mean, there are problems with the harm provision. I don't think we want to open up bail reform today. recidivism data at 6 months is an awfully quick turnaround. I don't want to speak to something I haven't had a chance to study. And I came here tonight to talk discovery. I have my hypotheses about why that might look the way it does, but I don't want to go off half-cocked. But the harm part of this, I think, our lived experience every day is that people repeatedly, when they already have a long record, don't care if they add a time served line on a misdemeanor. And that might not be just either, but it's an easy tool to make sure you don't walk out the doorbell eligible.
I was called on next, and I want to thank you, Andy. And I want to invite the others to please come to the 19th Precinct Community Council meetings in Community District 8, which is where you are now having this meeting. We hear about exactly what Andy said, these recidivists who have gone into Duane Reade 50 times, 60 times. The officers know who they're going after. Give it a day, 2 days, 3 days, and back again, they're in jail and they're out and they get dismissed because I don't know what piece of evidence it is that the discovery law that they didn't present. But when we go to our monthly meetings, the inspector and has whatever inspector we've had, because I've been a regular goer for the last 30 years, has talked about this as an issue. It's become more of an issue now in very recent years with the laws we have. I'm not saying that the discovery law should go away, but I definitely think it needs changes. One of the executive officers that was at our precinct, that's now someplace else in the police department, was telling me that 2 officers arrested someone at an event that happened, and he and 4 other officers were standing nearby, and they had to submit all their background papers as well as the 2 officers that made the arrest. He forgot to put down what college and what law school he went to, and the case was dismissed. Okay, it seems to me that some of the stuff that's being asked for in discovery is really not necessary, that these people just walk away. And as Andy said, you're not covering these chain store robberies, these other things, unless it gets to 40, 50 events of robbery. We had, I think, Nike and Lululemon, they closed or are closing because we've had so many robberies. They've had so much stuff stolen. It didn't pay them to be open any longer. So maybe what's happening in the 19th precinct in Community District 8 isn't the same that's happening around the city. But what I'm hearing tonight, I think that we are a large city. We need some changes in the law. We have a lot of crime because of the size of our city. And if this law was changed, if the discovery law was changed, I don't think it would hurt the people upstate, because if the changes were reasonable, that would be good for everybody, whether they live here or in Buffalo or wherever they live. So I do think there need to be some changes in the discovery law. I do not think it can stand the way it is now.
Judy, I'd love to know who told you about the law school college thing. We've had some bad discovery decisions that would take the cake by a mile and a half. So I'm a little skeptical about that, to tell you the truth. I think that cop might have been giving you a little bit of an excuse for something else that might not have happened. So there is a tendency that I've seen, and listen, I spend the other half of my day getting yelled at by the NYPD for being part of the woke Alvin Bragg office. So I'm not always on this side of the fence. That I think was we have plenty of bad discovery dismissals. I think that guy might have been giving you the runaround a little bit, but there are plenty of cases we can't pursue because of this law. I just don't, I don't want you to leave here with the perception that a cop not listening where they went to school is leading to a dismissal in New York. It's bad here. It's not that bad here.
Thank you, Andrew. Next up, Rita, and I just want to put out.
I'm really sorry, everybody. I'm being pulled to another discovery call right now, so I have to go talk about this more with a different crowd. But I really appreciate all the back and forth. I appreciate the discussion. If I can throw one more thing in, I'd love to get back to talking about expanding mental health treatment on every vector we can find. Maybe when this is all behind us, whichever direction it goes, we can speak with one voice um, on that front. But I think our community affairs team is going to leave at least somebody behind if there are questions, and I really apologize for having to jump to the next thing.
Thank you
Thank
for
you.
your, thank you. And I just want to put out there petty larceny, grand larceny, and robbery. Um, we have to be mindful of what these crimes are because somebody may say something was a robbery, but it's not. It could be just some type of theft, grand larceny, petty larceny. And those all hold different weights. And I just wanted to put that out there because a lot of people think a theft is a robbery and it might not be a robbery, right? So um, I'm not going into my little lore when I went through NYPD because we had to study everything, even as civilians. Up next, Rita. We're winding down.
I really don't know a lot about the law. Try to keep a straight and narrow life. I don't think that our systems work. I don't think that when we incarcerate people, that we don't educate them to be able to go out and earn a living. But let's stay with the discovery law. If you had one thing I'm hearing tonight, it's money, it is education, it is equipment, or in it. When I say equipment, I mean the equipment that we have today, the computers, the fast things, that things shouldn't get lost or shouldn't be in the, well, if you had one thing that you could change today, what would it be?
That's such a great, just one thing. I mean, I would turn it back to 2019 and make sure that the funding was part of this. It was a budget bill, so we would have been starting with funding from the start. And then I would also like that's what I would hope to change is like have it from the start for both sides, not just for the prosecutors, but for the defense as well. Which I think would have led, I would have hoped it would have led to less immediate backlash to that January 2nd backlash by prosecutors trying to roll these laws back in the first 24 hours.
Your job, meaning all the presenters, and besides that, thank you. That when people are acting and doing things that are terrible, and we are watching them on TV, and I will tell you it's January 6th, and then they are exonerated, it really makes it really hard to get somebody who is selling candy, without a license. And pinpointing them when we haven't pinpointed people who have really created egregious errors. Your job is very difficult. But it appears to me that you don't have the technology in the police department to do away with so much of this, of the errors that are involved here. But thank you for yours. And yeah, the only other standing man, what would be the one thing you would change? One.
Rita, thank you so much for your comments. I think that one thing that we can all agree on, everyone on the panel can agree on, is our desire for public safety. We want a world that is more safe. We want a world where there is less crime. And I think that where our disagreement lies is in what achieves public safety. And I am firmly convinced that evidence sharing does not jeopardize public safety. And one thing that I want is public awareness that evidence sharing does not jeopardize public safety. I think it's kind of easy to say housing and mental health are strongly correlated with public safety. That's certainly true. And our criminal legal system takes on so many challenging cases, so many people who are experiencing mental health issues. But the one thing that I would like is a recognition that holding prosecutors accountable for evidence sharing doesn't jeopardize public safety. And that recognition would allow us to address what really does impact public safety. That would be my one request.
Thank you.
Great, great. Okay, I guess Anthony, and then we're going to be wrapping up.
And Anthony, if you don't mind, just identify yourself. Look for a prompt on your device, Anthony. There you go. Oh, you muted yourself back. Let's try that again. Got it that time.
All right, cool. Can you guys see me? No.
Yeah.
Okay, maybe not. I don't know. Anyways, well, I wasn't gonna speak tonight, but I see that you guys, a lot of you made the effort. I know you guys work in this field, and I understand that ultimately you guys are trying to serve the overall community, whether, like you guys said, Albany or Manhattan or not. So I'm greatly appreciated that I was able to attend this tonight. I do want to state that let's just take a breather. I think that's the main thing about this is that a lot of Manhattan citizens are going through a lot of turmoil, and I understand 2020 was a lot. I understand 2019 discovery came about, and I understand that potentially that a lot of this is like a new beginning, and there's a pipeline of things to be more effective in the works. I think it's really great to understand that discovery is even in place, and I think it is great that some of you have like the stance on how you guys would like for it to be revised in a sense. Overall, I think um, it's a really great tool, and I also think that in great time, I'm sure you guys will get the technology up to par. Um, from different areas in Manhattan, or whether it's like in the Bronx or Brooklyn or God knows where else in New York. I know there's a lot of people that ultimately want to feel protected. Yes, safety is an issue, but protection is the main thing. And with Discovery, that allows a lot of the citizens to get that protection. And it's like by God's grace, they're able to get that through this. So that's also really cool. Um, Other than that, I don't really have much to say. I don't have much questions. I got all the information. I'm up to par. I guess I'm on the same page. But again, I just wanted to thank you guys and thanks.
Thank you. And I believe our manager asked you to identify yourself, but now you're muted. We see your name, but we don't know where you're from. Okay, but it's all right.
Oh, so I am currently in Upper East Side. My name is Antonio Martinez, and I don't know what else to state, but
We didn't know if he was aligned or anything. That's fine. Thank you.
oh no, I'm not.
Okay, thank you. Thank you for coming to the meeting. Eric, and then we're gonna
Yep. Hi, everyone. Thanks so much. Sorry I can't turn on my camera right now. Just wanted to let you know that we relayed the question to Andy, and I have a quick text response if we want to go back one pace. Andy basically just said expanded access to meaningful and well-funded treatment with real incentives for people to engage and consequences if they don't. And obviously changes to discovery was the final the final piece of that. Just wanted to relay it. And also, if anyone else has any other questions, I know we kind of mentioned it beforehand, but we're happy to relay them to Andy and we can get you guys an answer after the meeting.
Thank you. Last one, Rita, last hand.
I have a question. Do we need a resolution in support of the discovery bill that's up or not support it? Do we need it as of this meeting? As a committee?
So more was informational. Sarah, you want to chime in? If you can.
I think that whether or not we have a resolution is based on how our community board members want to respond to tonight's speakers. I think we've had a lot of information thrown our way, and this work also kind of just continues. And so I'm open to hearing how folks feel, and I'm trying to
how do we want our representatives in Albany to vote on this? It will come to a vote. Am I correct? Yes?
I it will, but not in the way that legislation usually does, because like we said earlier, as Valerie pointed out, it's part of the budget. So it'll be part of the entire budget bill that, helps fund our schools and like repair our roads. So it will come to, it's part of discussion right now, but that's part of the reason that so many, to Valerie's great point, so many big things are put in through the budget because there's power. If the governor wants this, she has more power to do in the budget. So it will come to a vote, but on the budget itself, if that's at all elucidating.
Thank you. So we don't need it if it's going to come to, if it's to the budget, but we want to be sure that our elected officials vote the way we want them to vote.
Yeah.
I think we're pretty consistent with our elected officials, that we know them very well, and they have always done right by us. So,
I do think, though, I mean, I'm sorry, Sarah, you didn't call on me. I mean, I just want to separate out the two proposals, though. I mean, we could, if you wanted to, have a motion to support, and I don't know the bill number, I apologize, for the sharing of data between the police department and the DA's office, because I mean, again, I'm speaking personally now. I don't think that should be controversial in terms of, I don't really see why that is even a thing, to be honest with you. But I mean, these two branches of government are supposed to be working together. I mean, maybe not together, but they theoretically are on the same side most of the time. So I don't see why they wouldn't be sharing information. But I don't want to, if there's a movement to agree that that should be done. I know that other boards, while they have shied away from just weighing in on the actual changes to the discovery law itself, have been taking a position on I'll call it the Lasher bill, okay, for lack of, to just bring it up to speed. But I will leave that up to you guys as the chairs as to whether you want to do that. And since I've already spoken, I can't make a motion, so I want to be cognizant of that as well.
we were supposed to be shutting down, but um, Jean and then Wendy, they haven't spoke. A public member, Wendy, but Jean.
Jean, you should have a prompt on your device asking you to confirm unmuting, and then you can speak. No, it should be there. Make sure you're in Zoom. I know. Wendy, you're unmuted. So while Jean's trying to find that button, maybe we go to you and let
Sure,
Jean
sure.
figure it out. I've sent you a few prompts, so.
Thank you so much. I want to thank everybody for a really great and thoughtful presentation. I'm coming from this from a sort of a different, from the umpire point of view, since I worked for a judge in criminal court. And I was surprised to hear that certain things were an automatic dismissal, but there used to be a lot more discretion. I'm talking about decades ago now. And I'm wondering if there's any impetus to looking at what the rules are for judges and how much discretion they have to see whether there's material harm or whether it's really de minimis, because it seems that some evidence is crucial, and that would really be up to the impartial party, presumably the judge, to take a look at. And I'd love to hear anybody's comment, but that would definitely affect what I think of in terms of what could be considered minor errors. And I agree with Valerie that most of these things are now entered into a computer. It's all computerized. It's not in a ledger like in the olden days. There should not be a problem with sharing evidence, and it's actually required. So I'm in support of full disclosure, but I'm also in support of judges having a certain amount of discretion to look at the totality of the case. And I will mute myself and listen to the answers. Thanks in advance. Much appreciation.
Thank you.
Wendy, so in people that's a great question. And in People versus Bay, the Court of Appeals discusses the factors that judges consider when they're assessing the reasonableness of a prosecutor's failure to disclose evidence. And one factor that judges are required to consider is the amount of discovery that's been disclosed and the amount of discovery that hasn't been disclosed. And so I think your concern about a de minimis non-disclosure is covered by the reasonableness standard that was articulated in Bay and the factors that judges are directed to rely on in assessing whether a prosecutor's disclosure has been reasonable. So I hear the concern, and I think it's been met by the Court of Appeals in People versus Bay.
I would just quickly push back, and I know Andy's not here, but I don't think he could disagree with this. There are no automatic dismissals unless the people are dismissing the case because they didn't bring anything. Like we all have dismissal lips. So I just wanted to dismissal lists. I'm sorry, I'm starting to lose not enough coffee today. Dismissal lists where the prosecution is just, agreeing to dismiss because they have never gotten the evidence or the statements to go forward.
I'm so sorry to interrupt. What was the form that was presented towards the beginning of this presentation where, because it wasn't given to the defense, the case was thrown out and the judge had no discretion?
But I don't know what that case is. Like they showed an arraignment form, but this is the point.
Sure, but it almost doesn't matter what the case is. The fact is that piece of paper, was it actually important? Did it disclose information that was crucial to the defense? And it looks de minimis perhaps to a prosecutor, but perhaps not to the defense. Well, I mean, we need to dig down into the actual facts, but isn't it for the judge? I mean, I had a judge and he would just say, I want to hear what the evidence is and I'll decide whether it's admissible or not, which is a little bit of a conflict. I get that, but it's done, that is done all the time. So
right. They still have that. This is the problem is like the question first is like, did the prosecutor take the steps to get the form? That's what I'm saying. To look at the case, I can't imagine it's just one piece of paper. Like, if you don't get to read the case, it's really hard to infer what that is, right? Because all I can say with certainty is what the law and the case law says. And that's that the question is about diligence. And as Professor LaFalle said, right, there's weighing, there's factors there that include all of that. Right. So like this notion of automatic dismissals, especially when cases are being dismissed misdemeanors between like 90 and 120 days, that's not enough time for motion practice for the defense to bring a motion to request dismissal. Right. That's happening within the time frame because the first steps of maybe getting the witness to what we call corroborate or just swear on a piece of paper that the thing that the allegations are happened indeed happened, that hasn't happened. So I think that's one of these like things that have been caught up, automatic dismissals that I just want to push back on respectfully and say it's like I hear these examples, these anecdotes, but unless I can see the decision, because if there's a motion brought, there's a decision in the case, right, that the judge writes. I want to read that decision to understand what else was maybe swirling around other than just that one piece of paper that was shown.
Thank you so much.
Thank you.
And
Does
Sandra, would I be able to jump in here really quick? I don't know if you guys can hear me.
I was going to call on you, which
Oh, perfect. Thank you. Thank you so much. So also, obviously want to acknowledge that Andy isn't here. So would love to, if there is more of a conversation to be had about the specifics, if it's substantive, that we can table it or we can loop Andy in. Obviously, we can get you guys any responses at a later date. So the case relating to the pre-arraignment report dismissal is People versus Aiken, Aiken. Just wanted to at least put that on everyone's radar. Of course, Andy actually texted it to us, but also wanted to highlight too, and I by no means am an attorney myself, so I'm, don't take this as me jumping in the ring here, so to speak. But I will say that I think a lot of the examples that were given before, basically indicating that a reasonable and diligent search would need to be conducted, is just want to highlight something that Andy said and emphasize that we are unable in many cases to conduct that reasonable and diligent search because we are conducting the reasonable and diligent searches on the higher level cases like the felonies, the rapes, homicides, things that are, in many cases, it's kind of the resource budgeting hours argument. So I just want to be clear that if it's saying that there is some kind of remedy based on the standard for what that search requires, it's that we're unable to conduct that level of a search on these cases. And Amanda's going to respond, but again, I would love for Andy to kind of pick this back up if we were able to table the discussion.
Yeah, but Eric, the problem with that is that your misdemeanor prosecutors handle misdemeanor cases and your felony prosecutors handle the felonies. And there's some trickle down, right? Because if a felony gets downgraded to a misdemeanor, someone might keep it. But I think that's all I'll say to that is I've heard this argument before in these forums, and I just don't think it's very I don't think it's very upfront with how the office itself is organized. And I just say that from experience of having worked at 100 Center.
Thank you. Thank you. We're trying to wind down and get everybody off this call, it looks like.
Jean did finally unmute, and so her hand went back down after she did.
So I would just like to say that there seems to be a little pause in terms of when I can unmute vis-a-vis when you're saying I can unmute. So I am adept at using Zoom. Thank you. But really, the conversation when I was not able to unmute was so much more substantive than anything I had to say. And I'm very, very grateful for the community board putting this together. It was so enlightening. The Committee for the Future of New York sent out an email today pushing for people to support the governor's proposal. And I called my legislators and tried to find out where they stand, and they don't know where they stand. And so, I'm trying to inform myself on this, and it was incredibly timely to get your email saying that you guys were discussing this and to have really smart, intelligent people presenting information on this. So I am in awe of our community board and the community board members and the questions they ask. And so that's it. Thank you very much for recognizing me. I appreciate it.
Thank you. Stay informed.
I'm glad we were able to unmute you.
Barbara.
I unmuted too quickly. I don't think we should have a resolution because I think there's too many unquestions. But the second point is, Valerie, to your point, and maybe Eric will answer this and everybody else, one of my ADA friends that I did speak a lot about to it gave an example of 5 different policemen with body cameras going, and then when the evidence came in, they couldn't figure out which policeman was which body cam, and it was dismissed. Maybe it was the judge that dismissed it. I don't know what, but it was not that they didn't get the body camera. They didn't get which police was the details of who did what and whatever. I think AJ is going to say that's not true. I don't know. This is what I was told by a very reliable, caring person that works very closely with the Innocence Project, by the way.
No,
We don't
just
know the.
I don't mean, I'm not trying to cast aspersions on anyone. I think it's just, again, that doesn't square with just how it works. Like, it's about the disclosure itself. We're the ones, if you work in Queens, the Queens DA still gives over all the discovery without file names. So we're sorting through like what belongs to what, right? Because each district attorney has a different way of doing it. So just I'm no dispersions cast, just that would be surprising to me if it was dismissed for that reason.
Right. So Valerie, okay.
I want to make a motion to adjourn.
Yeah, but we got to close out. We got to do,
That's fine. You can close out, but
we didn't say our final statement.
okay, no, that's
to get there. I was trying. I was like, here go Valerie again.
no,
Okay.
no.
Okay, perfect. Thank you to all the panelists, those that have attended, asked questions. This was very robust. Stay informed, engaged, and let's work on eradicating poverty, right? And at the end of the day, nobody wants to be on the other side of being arrested, and there's things that are not disclosed to help your case because you're innocent until proven guilty, right? Okay. So, Sarah, anything you need to say?
I will second Valerie's motion, and I will also say thank you so much to our speakers and to Eric and Julia for sticking it through with us all night long. And we're so grateful to have experts that we can go to on this very complicated topic. Thank you for beginning this conversation with us, and we'll see how everything evolves, and we'll continue to keep the community board updated on the course of this legislation. And I'm heartened to see that there's so much interest in this, because that isn't always the case in technical criminal justice issues. And so thank you everyone for joining and for staying until 8:42 tonight.
All right. Good night.
Thank you.
Thanks so much, everyone.
Thank you.